I'm joined now by Andrew Martin, founder and director of Fertility Law. Good evening. Thank you very much for your time. Are you familiar with the details of this case?
I've read the news articles relating to this case, but this is not necessarily an isolated incident when it comes to gamete donation in South Africa. So the facts are very similar to other matters that I've dealt with and am dealing with at present in South Africa. So it's going to become a far more prevalent query in our law at present.
Yeah. What does the law say, if anything, about the rights of a sperm donor regarding access to any child?
Yeah, so our South African law is actually really very clear on the parental responsibilities and rights of a gamete donor. And the law specifically states in the Children's Act at Section 40, subsection 3, that the gamete donor does not obtain any parental responsibilities and rights when he or she, for that matter, in the case of an egg donor, become a gamete donor for the purposes of artificially fertilizing a recipient parent. So the minute you consent and you become a gamete donor, you automatically, by virtue of our law, don't obtain parental rights and responsibilities. And I would assume that the point being argued in court is the best interest of the child query, which is paramount in all of these kind of decisions that the court is going to make to decide whether it's in the best interest of the child that the sperm donor in this instance actually continues to have contact with the child.
Yeah, I think that the issue of the child is crucial. I just want to try and understand, is there a difference in law between someone who gives sperm, say, to a sperm bank to earn money, and I presume also then signs away the rights, paid for that sperm, is paid for that donation, and someone who gives sperm perhaps to a same-sex couple who are his friends and says, you know what, I'm going to give this so that you can have a child. Is there any difference in law in that?
There is. So ordinarily, South African gamete donation is done on an anonymous basis. We have regulations to the National Health Act which specifically regulate gamete donation. And in those instances, the identity of the gamete donor, either obviously sperm or egg, are stringently protected by the law under criminal sanctions. So the gamete donor would then approach either a fertility clinic or alternatively a egg or sperm donor agency and would donate their eggs and their sperm. And then only certain physical characteristics would be able to be accessed and provided to the recipient parents, but no identifiable information. So they're an anonymous donation. However, the regulations make mention of when the parties are known to each other that they're required to kind of acknowledge the fact that they know each other. And in practice, in these instances, what we do is that we enter into a formal legal agreement, which we call a known gamete donation agreement, which then specifically regulates the parties' rights and responsibilities and records that the donor is a donor for the purposes of artificial fertilization, and ordinarily does not then get parental responsibilities and rights. So there is a differentiation in South African law. Ultimately, the net effect of both a known and an anonymous donation are such that the donor should not get parental rights and responsibilities. However, in this instance, in this case, they seem to have blurred the lines because they've already allowed the donor access to and contact with the child. So yeah, it becomes a little bit murkier and far more complicated.
Yeah, it certainly sounds like the lines have been very blurred here, as you say. So in terms of the law, he doesn't actually have any rights to access the child. But now, of course, it focuses on the rights of the child because it seems the same-sex couple allowed him to move next door, allowed a relationship, it seems, with his mother, in other words, the child's biological grandmother. That's my understanding anyway. So this, I would imagine the rights of the child supersede all of that. So where do we go from here?
Absolutely. So the court will then have to determine what's in the best interest of the child. You see, I mean, from the perspective of, a normal heterosexual biological father perspective, where the biological father is unmarried to the mother at the time of the birth, he will automatically obtain parental rights in certain instances, and those are he consents to be identified with the child, he contributes in good faith to the child's upbringing, and he as well as contributes financially to the child. So there's certain kind of conditional aspects that an unmarried father needs to fulfill in order to automatically obtain parental rights and responsibilities. And from what it appears from the facts of the matter is that he's kind of fallen into that category of, you know, the unmarried partner of the biological birth mother and contributed, had contact with, identified as the father. So he's kind of, in a way, stepped out of the role of a gamete donor and into the role of biological father. So the court's got a really difficult query to answer, because our law also doesn't necessarily make provision for the fact that a private contract can regulate parental rights and responsibilities that hasn't had judicial oversight. So that known donor agreement was never made in order of court, and there was never a declaration of parental rights and responsibilities at the time of them entering into that agreement. So the court can definitely overrule that and provide him with parental rights and responsibilities, or refuse to give him parental rights and responsibilities, but ultimately the court will look at what is in the best interest of the child.
Absolutely. Gosh, a very interesting case indeed. Thank you so much, Andre Martin, founder and director of Fertility Law.